song. Is it?
Anyway.
I'm Hayleigh Bosher. I am a legal academic and I research in the area of copyright law. As you know, Bill, I just wrote a book called Copyright in the Music Industry, which you kindly wrote a really nice comment.
Yeah.
What was really great is that Bill read it and was like, actually, Hayleigh, I wrote that law and you missed this part. So you're the best person to have checked it for me because you know it so well.
My name is Jules and I have had a very varied 30-year plus career in the music industry. I am a practicing attorney, to use Bill's parlance, but solicitor here in the UK, with a broad practice representing artists and many other entities in the music industry. But in my life, I've also been at a fairly high level, an A&R for Universal for 10 years, an international DJ, music maker, event promoter, manager, lots of stuff, some of which I do now, some of which is part of history. That's me. So I'd like to think I know a bit about the music industry.
I'm Bill. I'm a lawyer at Google. I've been a musician since I was 6 years old. I've been at Google since October 5th, 2006, but I've done a number of different things. And I've been practicing copyright law since 1982. And I've worked for Congress. I was Copyright Counsel to the House Judiciary Committee. I was a policy planning advisor to the Register of Copyrights. I was a law professor full-time for 5 years, an adjunct for 5 years. I was in private practice for 12 years, litigating copyright cases. So within the legal profession, I've always been a copyright lawyer, but I've seen it from a number of different perspectives. The last 14 and a half years from Google.
Tell me about being a lawmaker. Was that something you ever aspired to be, or did it just evolve that way?
No, I never aspired to be a lawyer. I never even planned to go to law school. In fact, I always disliked lawyers. Having graduate and undergraduate degrees in music, it wasn't the most natural courses. And the cases were really fun. They were great cases. There were cases that as a musician, what's not to love about it? You know, if you love culture, if you love art, if you love music, that's the course for you. And the case book was fantastic. I thought, oh, you know, law can actually be sort of fun and interesting. Law is a tool, right? It's not an end in itself. It's not something that you admire, like a beautiful statue or a beautiful piece of music or art. And it's only a tool, I think, to solve problems that law should solve. And so what we did was to first figure out initially whether this is something we should do. You know, you have to be humble about stuff. And it's hard to do that sometimes when you have the ability not to be humble, right? If you have the power to draft a law and to get it passed, maybe it's going to go to your head. Maybe you think, I can solve these problems. I can solve lots of problems. So the ability to overreach and draft things that you shouldn't do is really high. So the first thing that I learned is to really be humble. And unlike in litigation, where there's generally two parties, in legislation, there can often be dozens of parties with dozens of different interests. So you have a chorus of voices, very few of whom are saying the same thing. And that's an issue. The other issue is projecting into the future. Even if you could figure out at that time who's telling the truth or what the right approach is for that chess game that you're playing, you're playing chess for decades. And that's really tough.
And the blurred lines case is sort of known to many people as having been adjudicated or having been decided upon but by a jury trial.
I have said that the blurred lines case was a stain on the federal judiciary. It was a terrible opinion. I would say that subsequent to that case, a number of the things that caused that case to go the way it did are probably not the same anymore. So there was the Led Zeppelin case, the Stairway to Heaven case, right? So the Led Zeppelin case at the 3-judge panel court was just as bad as the blurred lines one. But that got reversed en banc in an opinion by Judge McCowan, Judge Margaret McCowan, who I think is, you know, one of our greatest copyright jurists. In that opinion, she did away with some of the things that caused the blurred lines case to go astray. I would like to think that if the blurred line case came after the Led Zeppelin case, it might be decided differently.
Fill in that gap that you were describing. The layperson could more readily compare a book or compare a work of art, whereas one is relying on the conduit of an expert in a music to make those same judgments in music.
That's true. I would ban experts. I think they're a blight on our system. So you got two experts, right? You have either a lay judge who doesn't understand any more than a jury does about music, one of those experts that uses a color theory. And so you have color-coded boxes, and juries or judges are comparing colors. They're not comparing music. It's a farce. And the blurred lines case, to me, that's where the problem occurred, is the misuse of experts. I would rather have this. There was a famous music case involving Creedence Clearwater and John Fogerty. So John Fogerty and his brother founded Creedence Clearwater Revival Band. It was a great 60s band. They, of course, transferred all the rights to the music company, and the music company, therefore, owned the copyright in their compositions. And everything was fine when everyone was making money, but then tastes changed, and they were less popular. The band disbands, and John Fogerty goes off. He does his own album, and he writes a song, and he sings the song. And you know what? It sounds like other songs that he wrote. Why? Because his voice is his voice. His genre, his style of music is the same. So out of spite, the owner of Fantasy Records, Saul Zaentz, sues John Fogerty for infringing his own song. Technically, that's an acceptable suit because Fogerty doesn't own the rights to his own song anymore, so he can be sued for infringing your own song. Whether they were the same or not was the question. There's a jury trial. And John Fogerty gets up there with his guitar, like the ones that Hayleigh has behind her, and he plays his songs. And the jury says, those aren't infringing. But I would rather have a situation like that where the musicians themselves actually testify and not having a battle of experts. So that's been a big problem in music cases, I think.
Talking about the Led Zeppelin case, I actually had that down as one of the questions to ask you, so I'm glad you mentioned it. You said that you thought that the judgment kind of corrected some of the issues that were created by the blurred lines judgment.
One of the main things that was fixed was the inverse ratio approach. So as much as I loved Mel Nimmer's casebook, historically there was a split. So I knew Mel Nimmer and I liked him a lot. He was a great guy. He worked for Paramount Pictures. And he, decided he didn't really like being an in-house lawyer. Maybe he thought of himself as, a more scholarly sort of guy. And he, went to UCLA and he wrote a one-volume treatise on copyright law. Then he ended up expanding it. And to make a long story short, he had the great prescience to have a multi-volume treatise. I think it was only 2-3 volumes at the time, when the 1976 Act passed. And the 1976 Act changed a number of things. So before then, within the copyright bar, there was something of a coastal split. The United States, in some ways, is a country of two coasts. There's the East Coast and there's the West Coast. And the West Coast in Southern California had a lot of copyright issues because of the movie studios, right? On the East Coast, especially in Manhattan, you had, Broadway, you had all the publishing houses, you had the music publishing houses, you had ASCAP and BMI there, you had all those sort of things. From a copyright perspective, they're very different too. Even to a few years ago, the East Coast people regarded the West Coast people as shiny suits and entertainment lawyers, sort of vacuous, LA people, even though Los Angeles was founded by an awful lot of people from New York. In terms of the movie studios themselves and in terms of some of the lawyers. So there was a split there. The people who were my mentors were the people in Manhattan. And we regarded ourselves as classical, traditional copyright lawyers. We learned everything. And I would say this is the point I had wanted to make too, is that I'm not an internet lawyer. I'm a copyright lawyer. And there's a huge difference between the two, not better or worse. The difference is this. Having been a classical musician, I regard myself also as a classical, traditional copyright lawyer. I was trained in the 1909 Act, 1976 Act, to learn everything. And at a time in the practice of law in the United States, at least in Manhattan, and Manhattan was at that time a really special place for copyright law. So the copyright bar in Manhattan, until maybe the last 15, 20 years, was an entirely Jewish affair. It was, the copyright bar was 90% Jewish. In fact, when I went to work for Google, I was stunned. I was one of the only few Jewish copyright lawyers, only few Jewish lawyers, period. It was stunning to me because I grew up professionally in a place where it was 90% Jewish copyright lawyers who grew up going to plays, going to concerts, representing, artists, publishers, authors, playwrights, everything. That was the culture. That was the tradition. The other part of that tradition was in developing younger lawyers, right? You stayed at your law firm your entire career. My mentor, when I was in private practice, retired after having been at that firm for 51 years. You didn't change firms. And when you were a young lawyer, they taught you. It wasn't about billable hours. It wasn't about making money. It was about learning a craft in the old medieval sense of it, right? You learned everything about it and you lived it. It was a profession. It's no longer a profession. It's a business. So that was my upbringing, and I was treated, like a grandson or a son. And, I had to get emotional about this. But it's not that way anymore. So with Nimmer, his stuff was not out of that tradition. His was a different tradition. So to be precise here and get my emotions back, he had all these crazy theories that sounded great, but that were ridiculous. So in the Led Zeppelin case, it was the inverse ratio rule that the amount of access that you needed to prove copying varied with the amount of copying you needed, right? So we all know to create a prima facie case of infringement, you need to know you own the work and that the person copied. So how do you prove they copied? Well, maybe they admit it, or maybe there are facts that show it. There's this one case where the defendant admitted he taped the plaintiff's work up above his office computer and looked at it. Okay, that's good proof. There used to be map cases where people would put false addresses, and then the defendant said, "Oh, that's my map. I actually went out there. I drove every one of those miles. But then there's a false street there." Right? So you can prove the person copied that way, right? The other way, of course, is to prove that works are generally available. So in the Led Zeppelin case, the plaintiff's work was widely available. Led Zeppelin may have been on the same stage when that work was performed, so you can prove access inferentially because, it's there. And then the person had the opportunity to copy. And then it's the question of, are they substantially similar? Did you copy a material amount of that? Okay, but they're two different inquiries, right? You could have 100% access to something and not copy it. That occurs every day. So access only matters to prove the absence of independent creation, because in copyright, independent creation is a complete defense, right? You could have someone on the West Coast, someone on the East Coast, and they come up with the identical thing, and if they never saw each other's works, that's totally cool. So you've got to prove access, but once you do that, forget about it. Then you go on, are the two works substantially similar? Nimmer, in his inverse ratio, said, no. If there's a lot of access, the amount of substantial similarity is small. If there's a little access, the amount of substantial similarity has to be great. And that was crazy.
Bill, thank you so much. It's been a real pleasure and very enlightening talking to you.
Hayleigh.